When a Minnesota railroad needed to buy new iron rails, it likely didn't expect that its negotiations with an Ohio metal manufacturer would become a textbook example of how not to accept an offer. Let's see what went wrong for the railroad and what we can learn from its mistakes in Minneapolis and St. Louis Railway Company versus Columbus Rolling Mill Company. On December 5, 1879, the Minneapolis and St. Louis Railway Company wrote to the Columbus Rolling Mill Company and asked Columbus to quote a price for 2,000 to 5,000 tons of iron rails to be delivered to the railroad in March of 1880. On December 8th, Columbus wrote back to the railroad and said it'd sell 2,000 to 5,000 tons of iron rails for $54 per ton. Columbus said that if the railroad accepted its offer, Columbus expected to be notified before December 20th. On December 16th, the railroad sent a telegram to Columbus that asked to enter an order for 1,200 tons of rails as per Columbus's December 8th letter. The railroad followed the telegram with a letter to Columbus reiterating its order for 1,200 tons of rails. The railroad asked Columbus to send it a contract for the purchase of 1,200 tons of rails at $54 per ton. On December 18th, Columbus notified the railroad that Columbus couldn't book the railroad's order at that price. On December 19th, the railroad sent another telegram to Columbus, this time asking to enter an order for 2,000 tons of rails as per Columbus's December 8th letter. Columbus didn't respond, and the railroad sent another telegram on December 22nd asking whether Columbus had entered its order. Columbus again didn't respond, and the railroad kept trying to follow up. Columbus finally responded on January 19, 1880, and said that the parties didn't have an agreement. The railroad brought an action against Columbus in federal district court, alleging that the parties had a contract as of December 19, 1879, for the purchase of 2,000 tons of iron rails at $54 per ton. Columbus denied making any contract. After a trial, the jury found in Columbus's favor. The railroad sued out of a writ of error to the United States Supreme Court.